అందరికీ శుభోదయం. Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukha. Yesterday, Acharya Nagarjuna University conducted the CPC examinations, in which the topic of cause of action has come. Therefore, I am making this video on the characteristics of a valid cause of action. Friends, you know, in the frame of the suit, while dealing with Order 2 and also institution of suit Order 4 and a part of Order 7, I told you how a plaint should be drafted, and the plaint should contain the basis, that is brief description. Then the important point is cause of action. Cause of action is nothing but the bundle of facts which give rise to a right or a liability. No doubt, nowhere in the CPC the word cause of action was defined, but still, in the case of Messrs. Sonic Surgicals versus National Insurance Co Ltd. 2009, it was held that cause of action means a bundle of facts which gave rise to a right or a liability. Cause of action is a sine qua non for the ultimate, that is success of the suit. It must be there for getting success in the suit. Entire suit revolves around the cause of action. Now, you know, there are two words. It's the term cause of action, and of course, even though it is not defined, it is left to the judiciary for interpretation. Therefore, I have given the definition in Messrs. The Sonic Surgicals. There are two words, cause and action. What is cause? Cause means existence of a legal right. Cause, there is an existence of legal right and violation of the same, violation of the legal right. That is cause. ఎందుకు వచ్చింది? నాకు అటు పోయే హక్కు ఉంది, వాడు అడ్డం వచ్చాడు. ఎస్, దట్ ఇస్ ద కాజ్. దెన్ యాక్షన్. యాక్షన్ మీన్స్ రైట్ టు యాక్ట్. దట్ మీన్స్ రైట్ టు ఇన్స్టిట్యూట్, రైట్ టు ఫైల్ ఏ సివిల్ సూట్ ఫర్ వైలేటింగ్ దట్ రైట్. Cause and action. Because of that cause, we have to take action. Because he violated the law, we have got a right to file a case. That is cause of action. For example, the plaintiff P is peacefully residing in a house or in his apartment. The defendant D has come opposite to his portion and started committing public nuisance. Then here the A has got a right to live peacefully, but it is violated by the defendant. Therefore, the plaintiff has got a cause to file the suit, cause to take action. I think you might have understood the meaning of cause of action. Right? So, in the Todd's time, 1873, I think, in Coke versus Gill, is a very landmark judgment on the cause of action. In Coke versus Gill, it was held that cause of action means every fact which is necessary for the plaintiff to prove. In civil cases, the burden of proof lies on the plaintiff to prove his case. Coke versus Gill. Now, let us understand the general characteristics of the cause of action. Please remember, the cause of action must be based on legal duties. Legal duties. That's why Winfield definition of the torts lo meeku cheppanu. The public have got a general duty toward the society. The public have got a general duty toward the opposite person. Likewise, so the defendant owes a right to the plaintiff and it should be breached. Then only you will have a right. So that is legal duty. The second point is, it should cause some injury. Law of torts lo meeku baga explain chesanu. So due to the act of the defendant, some injury should have been suffered by the plaintiff. Then there should be a cause. This is causation. The plaintiff is burdened to prove the so-called casual link between the injury and the breach of injury by the defendant. Ultimately, fourth one is you will claim damages. Damages, if injury is to the plaintiff is quantifiable or accountable, definitely he is entitled for damages. This is regarding cause of action. Normally, in the plaint, you write the brief facts, you give the details of the parties, then the brief facts, then the cause of action. Cause of action should be brief, cause of action should be correct, cause of action should be to the point. అండ్ నార్మల్గా మన టైపిస్టులు ఏం చేస్తారంటే కాజ్ ఆఫ్ యాక్షన్ అంటే పైన బ్రీఫ్ యాక్షన్ తిరిగి కొడతారు, 2 పేరాలు తీసేది కరెక్ట్ కాదు. వై దిస్? సపోజ్ యూ గేవ్ మనీ టు బీ అండర్ ప్రామిసరీ నోట్. కాజ్ ఆఫ్ యాక్షన్ ఎప్పుడు వస్తుంది? వెన్ హీ బ్రీచెస్. మీరు నోటీస్ ఇచ్చినా అడిగినా వాడు తిరిగి ఇవ్వలేదు అనుకోండి, అప్పటి నుంచి కాజ్ ఆఫ్ యాక్షన్ స్టార్ట్ అవుతుంది. దట్ యూ హ్యావ్ టు మెన్షన్. పార్టీషన్ సూట్ ఉంది. పార్టీషన్ సూట్ మీరు ఎప్పుడు వేస్తారు? మొదట్లో అందరూ కలిసి ఎంజాయ్ చేస్తూ ఉన్నారు, కానీ మీ పార్ట్ ఇక్కడ కాదు అక్కడే పొమ్మన్నప్పుడే దెన్ ద కాజ్ ఆఫ్ యాక్షన్ అరైజెస్. బేసింగ్ ఆన్ కాజ్ ఆఫ్ యాక్షన్ ఎంటైర్ కేస్ రివాల్వ్స్ అరౌండ్. ఆల్రెడీ ముందే చెప్పున్నాను దానికి, రైట్. అలాగే ఇఫ్ దెర్ ఇస్ నో, మరి కొంతమంది ఉంటారు కేసులో, ఇఫ్ దెర్ ఇస్ నో కాజ్ ఆఫ్ యాక్షన్ వాట్ విల్ హ్యావ్? ఇట్ విల్ బి రిజెక్టెడ్. ఆర్డర్ 7 Rule 11. It will be rejected. So this is equal to decree. Rejection of a plaint is equal to a decree. If there is no cause of action, it can be rejected. Order 7 Rule 11. Cause of action as the main substance of the suit. Court has to settle the issues basing on the cause of action. If no cause of action, court rejects it and it is equal to a decree. As stated in the case of Dahiben versus Arvind Bhai, kalyanji, Bhansai. Dahiben, ఇది గుజరాత్ కేసు లాగా ఉంది. Dahiben versus Arvind Bhai, kalyanji, Bhansai 2020. Held that where there is no cause of action, yes, the suit is rejected. Then purpose is, please remember why it is rejected. The purpose of rejecting to stop the sham, SHAM, చెత్త కేసులని ఆపేయడానికి, and the meaningless litigation stop చేయడానికి, and prevent the waste of judicial time. So friends, I have mentioned 3 case laws actually. Coke versus Gill, మొదట్లో నేషనల్ ఇన్సూరెన్స్, 3వ కేసు కూడా చెప్పాను. ఈ 3 కేసులు కాజ్ ఆఫ్ యాక్షన్ నేను చెప్పిన బ్రీఫ్ ఫ్యాక్ట్స్ కలిపి మీ భాషలో మీరు రాసేయండి. I hope definitely you will get good marks in the examination. With this fond hope, I am stopping here. Thank you very much.